So it is exactly 3 o'clock or 3:30, and I'd like to call our very first meeting of the Reapportionment Task Force of Thursday, April 22nd, 2021 to order. Before we begin the roll call, first of all, I would like to thank you all for agreeing to attend this very important next series of meetings that we're going to be having. Your input is going to be vital to the redistricting of Kane County for the next 10 years. So it's going to be a thoughtful, meaningful process to work in what I hopefully is going to be an effort between amongst us all that is going to fairly represent not only our parties, but also, welcome. Welcome.
There was anybody that was pressed. I'm not sure it was by accident.
It's under that table.
There's a button under your,
Okay, with an
under your
accident.
table. And
Absolutely.
Okay.
Yeah.
We're not panicking yet, but thank you. That's a way to start it.
go.
No, yeah.
It's just like you have in your office, the two buttons. So, well, we know the police work.
The buttons
Oh,
work.
works, right?
It works. I was going to say after probably the second meeting when we're not so friendly with each other, we may start panicking at that point. But also the task force, I think, I'm hoping, is really going to fairly represent how our communities, our mutual communities have all grown, expanded, and changed, and that minority populations are fairly represented as well as all of our celebrating our diversity to make sure that they are represented in districts which will allow the opportunity for them to have a voice along with all of us. So it is equitably represented. It's going to be a lot of work. We've had some significant growth, but before that, many thanks, and the thanks are going to be continued throughout all of this. So clerk, could you please call the roll?
Ford,
Here.
Fries,
Here.
Gums,
Here.
Kenyon,
Here.
Martin,
Here.
Sanchez,
Here.
Shepro,
Here.
Strathman,
Here.
Gately,
Here.
Meyer,
Present.
Arnold, Mayor Shelkey,
Here.
Mr. Afif,
Here.
Hernandez, Pedersen, Rivera, Walter. Thank you.
And I'm sorry. Oh, no. Barbara. Brenda. Welcome. The mask. The mask. Okay, we're all here. So we have a reapportionment task force rules of order, and I would like to remind our advisory members that they will not be allowed to vote, although discussion on this table, when we start actually talking about the maps, your voice is equitably heard without question. But it only will be the board members who will be allowed to take actual vote to this. So did everybody get a copy of this? And have you had the opportunity to review it, or would you like to review it now? Why don't I quickly read it so that it's relatively short. We have our purpose of ad hoc committee, Kane County Reapportionment Task Force, is to make recommendations to the county board concerning the development of the county's reapportionment plan and related matters. Your names, if there's any change in your names, typos or whatnot, please let us know and we'll adjust that accordingly.
Mr. Sanchez is perhaps advocating a large increase in the size of the board to 124 districts.
This is true.
Madam Chair, I apologize. I don't
have a typo.
Madam Chair, I don't have a copy. I'm sorry.
Oh, you do not have a copy? Do you have an extra copy?
It's important.
This is going to be our rules of engagement. So I want to make sure everybody has
One
that.
of these. Here's the agenda now.
Madam Chair, was it distributed digitally? Because I don't know that I received a copy. This is Mr. Sanchez.
Yes, Jane did send you a copy earlier.
Okay, I'll double check that. Thank you.
If not, if you don't have it, if you could just write to Jane really quickly. She's upstairs and she'll get it to you. Yes. All right, we all beginning? All right, let's go through our rules of order. Voting members of the task force shall have the right to make motions, debate, and vote on any motions properly brought before the task force. A majority of voting members present is required for the passage of a motion. Advisory members shall be advisory only and shall not have the right to make motions or vote on any motions properly brought before the task force. They shall have the right to debate and speak on any matter before the task force. The Illinois Open Meetings Act shall govern the conduct of the task force with respect to the establishment of a majority of a quorum and the notice of posting requirements of meetings. Voting members only shall be counted in determining the establishment of a quorum to begin a properly noticed meeting. However, a member's voting status shall not affect requirements set forth in the Open Meetings Act for properly noticing and holding meetings. The membership of the chairman shall be in addition to the number of members and shall not be considered in the determination of the quorum needed for the conduct of business of the task force. The chairman shall be entitled to vote only in the case of a tie, unless their presence was required to constitute a quorum at a meeting, in which case they may vote on all questions coming before the task force at that meeting. So hopefully we will have a unanimous vote on most of our things. All other rules of order and rules concerning the conduct of meetings not specifically set forth herein and not in conflict with those specifically set forth herein shall be those set forth within Section 2-47 of the Kane County Code, including that Robert's Rules of Order shall govern the conduct of meetings where not inconsistent with specific rules of order of the Kane County Board or of the task force. May I have a motion and a second to approve the adoption of the rules of order?
Also move. Second, Madam Chair.
And since people may be online, could you please remember to say all your names?
Shepro moves. Kenyon seconds.
Thank you. Thank you both. Is there any discussion? Yes.
One typo perhaps, under C on the second page, the chairman shall be entitled to, it should be chairperson, unless we want to just leave it
Chairman
as
is
is. Shall be entitled to vote only in the case of a tie unless her presence was required to constitute instead of their.
It can be a her.
And a question, just of interpretation. If I understand this, only the voting members are considered for determination of a quorum. Is that correct?
That's correct.
And so that then brings up the question of what is a majority of a quorum for the purposes of the application of the Open Meetings Act? Because if it's 8, that would appear that a quorum would be 5, and therefore a majority would be 3. That number could change, and if it, as I understand it, the Open Meetings Act will apply to the non-voting members as well in terms of offline discussions and so forth. I guess I'd ask the state's attorney if that's accurate.
That is accurate. Aaron Brady is on the line, who is our Robert's Rules person and typed up these rules. Aaron, do you want to comment?
Sure. So, Mr. Shepherd, the intention is that the terms of the Open Meetings Act apply to all members regardless of whether or not they're voting. So a group of, a majority of a quorum of non-voting members could not get together and discuss privately the public business that's before the committee.
So if a majority of a quorum is 3, then no 3 non-voting members could get together and discuss these issues.
If that's the breakdown, I haven't, with the
Yeah.
late breaking additions, I haven't done the math, but that would be the outcome. You know, and something that would be important to know, we'd also like to recommend that all members of the task force take the Attorney General's online Open Meetings Act training if they have not already done so. We think that would be good practice. If anyone would like assistance or direction on how to do that, please reach out and we'll be happy to guide you.
Would it be appropriate if that was just sent to all members of the task force?
That's no problem.
Thank you.
Thank you.
So with that one adjustment to their,
And on
To
page
her.
1 under the district.
so
for
we
Mr.
don't have
Sanchez.
124 districts
Yes.
as of yet. As of yet. Uh, May I have a vote? Roll call, please.
Ford,
Yes.
Fries,
Yes.
Gums,
Gums, yes.
Kenyon,
Yes.
Martin,
Martin, yes.
Sanchez,
Yes.
Sheffro,
Shepro, yes.
Strathman.
Strathman, yes.
Thank you.
Are there any public comments? Is anyone online? Hearing none and seeing none here, we can please move on to new and unfinished business. Before we begin, since this is truly an introductory meeting, and I know some of you may not have had a chance to meet each other previously, could we just do a quick round robin? And Mr. Meyer, we'll start with you and we'll just go around the room and just introduce yourself very quickly, please.
Thank you. Jeffrey Meyer, I'm here representing the Kane County Public Center.
Good afternoon. My name is Junaid the Thief. I live in Elgin, and I'm here representing the community.
Good afternoon. My name is Steve Arnold. I live in Aurora, and I am here representing the Kane County Farm Bureau.
Cheryl Strathman, District 20, Elgin.
All right, Brittany Pedersen. I live in Aurora and I'm an attorney in the Aurora, Kane County area, originally from Elgin, representing the community as well.
Michelle Gums, King County District 8.
Ron Ford, Kane County District 6.
Okay. Shelkey.
Jeff Shelkey, I'm the mayor of Batavia. I've had the honor now for 11 terms. I've been elected. I also have some other roles in the region. I serve as the chairman of the Chicago Metropolitan Agency for Planning's Council of Mayors, which represents the 284 mayors and village presidents that surround Chicago in the 6-county area. And we are the ones that receive and distribute the federal transportation dollars to the municipalities. So needless to say, from that position, I get to know most of the mayors in the area, at least hear their ideas and thoughts. So that's my background.
Thank you.
I've learned that it's always very difficult to follow Mayor Shelkey when it comes to a resume. My name is Ken Shepro. I'm the vice chairman of the board.
And also board member. Board member from what district?
Oh, District 12.
I'm Mike Kenyon. I'm from District 16 and the resident farmer on the board.
Drew Fraz, District 18, King County Board.
John Martin, District 11, which is about 80% of Geneva and the northern portion of Batavia.
Jeff Walter, Village President, Village of Elburn.
Mark Gately, I'm with the Kane Democrats.
Okay, very good. Brenda.
Brenda Hernandez, Aurora Township Trustee.
Okay, thank you. And Michelle, do you want to introduce yourself too?
Hi, my name is Michelle Neerman. I'm the Chief of the Civil Division of the King County State's Attorney's Office.
Thank you. So again, welcome all. So you're going to be tasked, this committee, with some serious work, and I mean that seriously. And as I mentioned earlier, very exciting work. If I could have the grace from the board members, some of this information you've already heard yesterday, but I've reviewed it several times myself, and I'm always trying to remember everything that I had learned and said, so it bears repeating. There's a different term between the apportionment and the redistricting, and you're going to be asked to consider doing both. The apportionment, first part of your exercise, is going to be the number of districts that are going to be available for future boards. You'll be asked to decide how many board members you would like to have, and if you would like to have a single, which I think we've already decided, a single district, which is what we need to have right now. You will ask also if it's going to be, I believe, at large or within the restraints of a district. So those are going to be the decisions that need to be made. Redistricting, and sometimes we use the word interchangeably, is going to be your next task, is actually taking a look at is it going to be 24, 22, however many districts this committee decides it would like to have. And then how are they going to change? Currently behind us, you'll see the 24 districts in different reiterations from past all the way to current. How the population have shifted, where the population movement is going to be happening, what the average size of each district is going to be. And again, a great deal of sensitivity to make sure we're in compliance with the Voting Rights Act. So that is going to be the major work that is going to be done for you. The board, so you know, once they receive this information, is also going to be looking at compensation for future board members. For instance, my position as chairman, this position has not received any additional compensation for 14 years. The board members, both past and future board members and current board members, have not received an increase in their compensation for 10 years. So this is going to be also being reviewed by the board, but not by this committee. Pending the decision by this committee on how many board members are going to be. And once the reapportionment occurs and the redistricting occurs, the board will also then decide what the term of office is going to be. If they're going to be in a 2-year cycle, 4-4, 4-4-2, or any reiteration thereof. So that will be decided as well. It has been suggested, mandated, it has to be done by September 1st of 2020. The board has elected to have that moved sooner than later. So that most likely is going to be happening before, hopefully by September of this year, rather than September of next year. So it's a lot of work. I would like now to have Assistant State's Attorney Ms. Neerman come up, and Mrs. Neerman, and speak to you about the Voting Rights Act and what the concerns are as we move forward with this reapportionment and redistricting.
Thank you, Madam Chair. Let's see, Ms. Blair. There we go. Before we get started, I just want to make a couple of introductions. I'm with the King County State's Attorney's Office. We do have on the line with us today via Zoom State's Attorney Masser, who I would like to introduce and allow her to make a couple of welcoming remarks.
Hi, can everyone hear me? So wonderful. First of all, my apologies for not being there in person. We have been doing a lot of trainings in the office, and one of those trainings is active shooter training. As you saw, when one of the buttons was accidentally pressed and our wonderful security came in immediately to make sure everything was good, I'm trying to make sure that in the event something like that happens here, that the people who work in this courthouse are ready for it. And tonight is my training, so it's very important for me to be there. Secondly, as you know, my name is Jamie Mosser. I'm the newly elected King County State's Attorney. I come with the experience of having worked in this office before and then having worked in the community as a private attorney along with a legal aid attorney. I am very lucky because I have about 120 amazing people who are really dedicated to making this office the best it possibly can and to be there for our county whenever they're needed. Michelle Neerman, as you are going to quickly find when she goes through this proceeding, is a very knowledgeable attorney who is going to bring a lot of experience to this process. I am very excited that we are going to be able to work with all of you. This is going to be very important work, and it's work that needs to be very transparent for our community so that everyone understands that we're doing what's best for our community. I'm looking forward to meeting each and every one of you throughout this process, and I look forward to making a new, better, different, whatever adjective you want to give to it as a part of this reapportionment and redistricting process. So thank you all very much.
Thank you, Jamie. The second person I want to introduce is Special Assistant State's Attorney Phil Lukahans. We have 8 attorneys in our civil division, and we are going to be here for you throughout this entire process. But we're also bringing in a Special Assistant State's Attorney who has an expertise in redistricting. Mr. Lukahans is an attorney from Itasca. He has been involved with redistricting matters since the 1990s and has been involved in redistricting litigation. So he brings a wealth of experience. He also has a tech person in-house that can assist and work with our county GIS department in order to help develop those maps as we proceed in the map drawing process. Phil, if you just want to say hi so people know who you are.
Yeah. Yes, Phil Lukahans, nice to meet all of you. I know some of you I met virtually yesterday, and I truly look forward to working with all of you to come up with a map and a plan that's satisfactory to everyone. So look forward to it. Thank you.
Thank you, Phil. All right, so we thought we'd begin the presentation today by just kind of going over the statutory framework that's going to be applicable to your very important work here. And if I can get the controller to work.
She might have to do it.
Okay.
You want to do it, Kelly?
All right. So what we're going to do is take a very quick overview. I apologize. This is going to be duplicative of the presentation from yesterday, but we did just want to give an overview of the various statutory framework that we will be working under. The first part of handouts have been provided to those who are in the room, and I apologize if we ran out of copies. But looks like we might have some movement on the screen. We'll just go ahead. So the first. So the Illinois Constitution will provide sort of the first sort of point of reference for us, and that's the Article 7, Section 3 of the Illinois Constitution, which sets out that the county board is to set by ordinance the number of county board members. With respect to the Constitution also tells us that the General Assembly is responsible for providing methods of election for county board members, and that any change in the method of election must be approved by a county-wide referendum. Part of the work of the task force is going to be to recommend to the county board, to have a discussion and to recommend to the county board the number of county board members to have on its board. Okay, next slide. Okay, so following its constitutional mandate, the General Assembly has set out the requirements for electing the county board members in the county's code. This section in front of you is 2-3002. It requires that the county board and counties with township form of government, which is Kane County, reapportion the county every 10 years after the federal decennial census, so that each county board member represents the same number of people. And this will then be, as the statute provides, the first step in the reapportionment process, determining the size of the board. The statute tells us that the board has to be between 5 and 29 members. We're currently at 24 members. Next slide, please. There is a special limit that was designed for DuPage County when it exceeded 800,000 in population. And it sets its board at 18 members. So it generally defines a county who is in excess of 800,000, but less than 3 million, which is Cook County. And that population determination is made as of the decennial census in 2000. In anticipation, the legislature would also include future counties in this 800,000 mark. In 2011, the King County Board reduced its size from 26 to 24 so they could progress at a sort of an even pace towards that 18-member mark. The current data estimates that we have right now to work with suggests that the county will not reach 800,000 until approximately 2050. That's 2050. Next slide, please. Section 2-3003 is really the meat of the apportionment plan, the requirements of the apportionment plan that you're going to have to develop. It sets out 4 basic requirements. The first is that each district shall be substantially equal in population to each other district. Each district shall be comprised of contiguous territory as nearly as compact as practicable. It may divide townships or municipalities only when necessary to conform to the population requirements. Paragraph A above, which is equal in population. And D shall be created in such a manner so that no precinct shall be divided between 2 or more districts insofar as practicable. As noted on the slide up there, population is defined to mean the number of inhabitants as determined by the last preceding federal decennial census, which is the 2020 U.S. Census. Next slide, please. And next slide, please. Okay, so in order to begin the map drawing process, the statute provides that the chairman may, which is optional, present a reapportionment plan to the county board. We are following this task force procedure so that the task force can make recommendations. It all depends on the timing of the receipt of this U.S. Census data. Unfortunately, in this particular year, which we'll discuss a little bit more, the U.S. Census data has been delayed. So this is an optional step and most likely a step that we will not be utilizing. Next slide, please. This section 3004 sets a statutory deadline of July for completing the reapportionment process. If the county does not complete its plan, the county clerk is required under this section to convene the County Apportionment Commission. The County Apportionment Commission would consist of the county clerk, the state's attorney, the attorney general or his designee, as well as the 2 political party chairmen from the central committees. Next slide, please. Further procedures for the if a commission is convened. Next slide, please. 3005 basically requires that once the plan is completed, it be filed with the county clerk. Next slide, please. 3006 sets out the consequences for failure to file a plan and states that if no plan is filed with the clerk, the county board members are elected at large. Next slide, please. This just talks about the election of the chairman. That's just for your reference. It's not applicable in our consideration for this task force. Next slide, please. Similarly, at the time of reapportionment, the county board determines the salary for its county board members and its chairman. But again, that will not be applicable to the work of this committee. Next slide, please. Similarly, the county board will draw by lot the terms for the staggered terms of the county board members to be elected after reapportionment. So that is done after the reapportionment process. Next slide, please. Finally, in terms of the major tasks that have to be accomplished during reapportionment, at the time of reapportionment, after it usually happens simultaneously and then just right after, there's an adjustment of precincts that's done. So you will hear of that and probably will be providing input on the adjustment of precincts. All right, next slide, please. And then we can go to another one. If you could forward to equal protection. Slide, please. Thank you. Next one. Great, thank you so much. Okay, so in addition to the state legal requirements, reapportionment plans are also subject to federal equal protection requirements as well as non-discrimination requirements. With respect to equal protection, and we're talking about the Equal Protection Clause of the U.S. Constitution. The Equal Protection Clause requires that districts must be equal in population. This is known as the one person, one vote rule. You'll know the similarity with the statutory requirements, the Illinois statutory requirements, which require a substantially equal population for each district. To achieve the equal population, the ideal district size is determined by dividing the total population for the county by the number of seats involved. So we'll need that data, but ideally we would have our US Census data to determine the total population of the county, and then we will divide it by the number of seats that the board adopts by ordinance. The US Supreme Court has held that population deviations greater than 10% are presumptively discriminatory, and when challenged must be justified. Next slide, please. Similarly, population deviations of less than 10% between the smallest and largest district are presumptively valid. Deviations in excess of 10% can be held valid if there is a compelling state reason, such as ensuring compactness or contiguity or maintaining the integrity of political subdivisions, etc. Next slide, please. So we have equal protection on the federal side. We also have non-discrimination laws, which are enacted through the Federal Voting Rights Act. And in particular, with respect to reapportionment process, Section 2 of the Federal Voting Rights Act. Next slide, please. All right, so the principles of Section 2 of the Voting Rights Act includes Section 2 prohibits any voting practice or procedure that results in the denial or the abridgment of any citizen's right to vote on account of race, color, or status as a member or status as a member of a language minority group. A voting practice or procedure has a discriminatory effect and is prohibited by Section 2 if, based upon the totality of the circumstances, minorities have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. Section 2 of the Voting Rights Act also requires that a racial minority have the opportunity to elect a candidate of choice, not that a particular percentage of minority voters be present in a district. Section 2 also prohibits the enactment of redistricting plans and other voting practices that were adopted with a discriminatory purpose. So that's intentional discrimination. Next slide, please. So we referenced before that we cannot deny or abridge a person's right to vote of minority groups based upon race, color, et cetera. Part of that abridgment is vote dilution. So vote dilution is prohibited by Section 2 of the Voting Rights Act. Vote dilution refers to the use of redistricting plans and other voting practices that minimize or cancel out the voting strength of the racial and other minorities. Court precedence establishes that districts cannot be drawn where minority voting rights may be adversely impacted by diluting the voting strength of minority populations. Voter dilution has been defined as fragmenting large concentrations of minority populations into separate districts or concentrating minorities into districts in which they would amount to excessive majorities. So the essence then of Section 2 claim would be that a certain electoral law, practice, or structure interacts with social and historical conditions to cause an inequality in the opportunities enjoyed by minority and white voters to elect their preferred representatives. As noted by the district court here in Illinois, vote dilution is most often attempted either by scattering the minority voters among several districts in which block voting majority can outvote them regularly, or by centralizing them into one or two districts and leaving the other districts relatively free from their influence. Next slide, please. So we have up here an example of what has been held to be invalid. There's a South Dakota redistricting case that was found to be invalid by the 8th Circuit, where the redistricting plan packed into one district. It was packed with 90% of American Indians in that one district, and it was right next door to a district with 30% American Indian population. So those districts could have been evened out a little bit more to make sure that there was an influence in both districts. So that is an example of packing. Next slide, please. All right, so court precedence has established various factors for proving a violation under Section 2 of the Voting Rights Act. These are known as Gingell's factors. You don't need to remember that. It just simply comes from the name of the court case that established the factors. So some of the factors the courts consider include, and this is what plaintiffs must prove. First, the racial or language minority group is sufficiently numerous and compact to form a majority in a single member district. The racial or language minority group must be able to show that it is politically cohesive, that is, that it votes for the same type of candidate. And third, the racial or language minority group must be able to demonstrate the white majority votes sufficiently as a block to usually defeat the minority's preferred candidate. In a later case, the Supreme Court added on that a minority group be a numerical majority, that is 50% plus one of the voting age population in order for Section 2 of the Voting Rights Act to apply. So if a plaintiff then establishes these factors, the next question then is whether the totality of circumstances, under the totality of the circumstances, the minority group has less opportunity than other members of the electorate to participate in the electoral process and to elect representatives of their choice. And next slide, sorry about that. And next slide, please. So what is the role of race? So in drawing district maps, it's not always impermissible to consider race. Race is actually a permissible consideration in redistricting if and when it's necessary to satisfy a compelling state interest, such as compliance with the Voting Rights Act. Merely being race conscious is not itself illegal. A redistricting plan will not be held invalid simply because redistricting is performed with consciousness of race or because of jurisdiction intentionally creates a majority-minority district. A plaintiff challenging a plan must show that the legislature subordinated traditional race-neutral principles to racial considerations. Race must be the predominant factor motivating the redistricting decision, not just a motivation. Next slide. So taking the state and the federal legal requirements together, what are sort of the rules for drawing map lines? And again, these rules are very generalized, all have a lot of nuances, but we just try to get set out for you some more simple type of rules. So under the state statutes and U.S. Equal Protection Clause, districts must be substantially equal in population. They must be comprised of contiguous territory as nearly compact as practicable. Townships or municipalities may be divided only when necessary to achieve substantially equal population. No precinct shall be divided between two or more districts insofar as it's practicable. Less than 10% population deviation from the smallest to the largest district is presumptively valid. Greater than 10% population deviation is presumptively discriminatory. Next slide, please. So those were the equal protection and the state requirements. Under the Federal Voting Rights Act then, some basic rules are, in drawing the map lines, the county must not discriminate based on race, color, or status as a member of language minority group. The statute defines language minority groups as including American Indian, Asian American, Alaska Natives, or Spanish heritage. Spanish speaking. County must not intentionally discriminate when it's drawing the lines in any case. All intentional discrimination is prohibited. The county must not dilute voting strength of minority groups intentionally or unintentionally. This includes the county must not fracture minority groups into small pieces across several districts so that the population has very little impact on the election. And it also must not pack minority groups into a few supermajority districts, taking away voting impact of the minority group from other districts. And finally, majority minority districts must be drawn where minority groups constitute 50% plus one of the voting age population. Next slide, please.
Can we have a question at this point?
Sure,
Sure.
absolutely.
Michelle, if you go back to the last slide. So, sorry. This is Shepro, by the way, for those online. So the last couple of points sounds a little bit like the manager's admonition to the pitcher, don't walk him, don't give him anything good to hit. Because if I read this, you may have to create a supermajority district to comply with the Voting Rights Act, but you can't overpack it apparently. What guidance is there in the cases about that? Or is it pretty much each case rises or falls on its own unique statistics?
I think it's very dependent on unique characteristics of the population. And I'll ask Phil Lukihans, who he has dealt with more of the litigation side of this. In terms of Phil, can you add anything to that?
Mr. Shepro, you're absolutely correct. It is kind of a fine line you're walking. And then you add the fact that you can't draw primarily with race, and the courts have kind of put you in a position that you're walking up. You're right, a fine line. There is no, I would not recommend that you have a numeric number you're trying to hit, because once you do, now you walk into this issue of you're drawing primarily based on race. There are some things that obviously, if you are drawing a majority minority district, you have to have more than 50%. You also look at things such as citizenship as it relates to Latinos, because a certain percentage are not. So you have to build in a greater percentage on Latino districts, especially in those areas that have heavy non-citizen population. There used to be, when I started this thing, there used to be a rule you needed 60% African Americans to have an effective district, because historically African Americans had more families, or had larger families and younger kids because of the larger families, and were not as many registered to vote. And it was 65% for Latinos. That's gone by the wayside. And what you would try and do is check these districts to make sure they are effective. And we can help you do that as we go forward as to what an effective district is. And I know that sounds like I'm waffling a lot because the law is not real clear and I can't give you a specific numeric target, but it's one of those things where I think we can help you get there.
I guess what I'm hearing is that just saying 70% or 60% is a dangerous approach.
Yes, and if you took a district, and Michelle gave you the example of the Indians out in, I don't know if it was South Dakota or wherever, but if you did put, if someone, not suggesting this county would do that, but if someone put 80% of the Latinos in a district, and next door was a 40% Latino district, you would run into a problem. That's the kind of packing you have to avoid. So while at the same time trying to make it so they have an effective opportunity to elect.
Thank you.
Any other questions?
No? Okay, fantastic. Thank you, Phil. Next slide, please. All right, so we just wanted to kind of outline the various tasks that are to be completed by the county board and will require input of this body, of this task force. The first step, as we've mentioned, is that the county board has to determine the size of the board. And that should be done as soon as possible. Ideally, this would be done, before the middle of May, if at all possible, so that we can then proceed to analyze the data based upon the number of districts the county board has enacted. The second task then is to determine the ideal district size. Again, this is the ideal or the total population divided by the number of districts. Now, the total population, again, by statute, is supposed to be based upon the US Census data, which we do not have. We do have some other types of data that we can use for preliminary planning purposes right now until we have US Census data, or we have a legislative fix that allows us to use some other type of data. Typically, I just wanted to note the US Census data is usually out in March or April. By comparison, this year, due to COVID, it won't be out until the end of September, is what the website says. We might have some raw data in August that we may be able to use. Okay, next slide, please.
Question on,
Yes.
again, if you go back to the slide you just did, Michelle.
Could you?
The referendum question. I think we touched on that at the board meeting yesterday, but if I understand, I mean, statute cannot trump the Constitution.
Correct.
So does that mean that effectively we can't change the method? I mean, if we had a referendum, we wouldn't meet any of the deadlines. It couldn't go on the ballot before next March. So perhaps that may moot some of the discussion about other alternatives.
That is our interpretation.
I agree.
That is our interpretation. So what we would do to comply with the statute is simply restate that we are electing members from single member districts.
Single representative, single member.
Yes.
Correct.
But if we were to say, we're going to go to 12 two-member districts, it would be your opinion likely that would, if challenged, would not succeed until there's been a referendum.
Yes, that is correct. It says only changes can only be made by countywide referendum. Yes, thank you for pointing that out.
So just to confirm this, when this committee this task force makes this recommendation, it can go up to 29, or it can go down to 6.
5, actually.
5.
I recall imperfectly something that suggested that once you had gone down, you couldn't go back up.
There's a reference in there that as of, I think it was in the 1960s or something, you couldn't exceed your board size that was in existence on a certain date. So we would determine, what that was. And I don't have the answer right now of what our board size was in I think it was the 1960s.
I think it was 42 then.
Okay.
Because all the township supervisors were part of the board. Thank you.
Yes, thank you. Any other questions?
Okay,
Michelle.
thank you. Next slide, please. Okay. All right, so once the ideal district size is determined, once you determine the size, the county board determines the size of the board, the ideal district size is determined, the county board will then proceeds to develop a plan, a reapportionment plan. We are utilizing the task force in the county to make recommendations and to help develop those preliminary plans for the county board's consideration. Again, normally plans are developed in May and June. We're still going to try to do that in terms of developing a preliminary plan. Obviously, 800-pound gorilla in the room is the fact that we don't have our US Census data. Again, as pointed out up here, the deadline in the statutes, which has not been changed at this time, is July for the county board to complete its reapportionment. In addition to drawing the maps, we've gone over the other types of things that the county board does. You see there at the last bullet point that simultaneously with all of this reapportionment, we're also going to be looking at adjusting precincts. The precincts are supposed to be between 500 and 800 people, or voters, I'm sorry. And, we have far in excess that in many, many precincts. Next slide, please.
Yes, Mr.
Question on
Shepherd.
that slide, the last one. So under the compensation, that you're using the term at time of reapportionment, and then at the bottom, we're saying simultaneously with reapportionment. Do we have to make the compensation determination literally in the same ordinance or whatever for compensation as the map itself? Or is it within some reasonable time frame? And I guess the same question about the adjustment of precincts.
Precincts have to be adjusted.
So the statute uses at the time of reapportionment for the salary portion of it to determine the compensation. So it is a shall determine at the time of reapportionment compensation to be paid. In essence, is what the statute says. There's no consequence for that, except that you do need to set a salary, and I've got to refresh my recollection on the statutes. You've got to set the salary prior to the next election or it's not valid. You cannot, a board member, but the case of the
That's
law
180
provides
days.
you can't vote yourselves a pay raise during your term. This has to be applicable to a future board.
Future board. Yeah. I believe it's 180
180 days prior to the election for the term at which the salary would take effect.
Correct.
Correct. That's correct. That is correct.
So you have that for this compensation. With respect to the adjustment of precincts, the county board does have a duty under the statutes to adjust precincts every year. And that usually that happens in June. I can think of every year, June, July of every year. There is there's no consequence necessarily for not adjusting it. It basically says that if you don't do it at that time window, it kind of, you do it next year, basically, is what the statute says. But it does have a provision within the adjustment of precincts under the election code that you are supposed to do it after reapportionment, after legislative districts are drawn, et cetera. So it is a mandatory, but there is no consequence in that section of the statute.
Isn't there also another section that mandates the state's attorney to bring an action to divide precincts under another set of guidelines?
It provides that elector can ask the state's attorney to do that.
I'm going to ask, we are, because of sensitivity of time, we have several other opportunities for presentations.
Okay, all right. All right, so if we move on to the next slide then. All right, so as we touched upon, the largest challenge for us this year is the fact that we don't have US Census data. The statute requires that we use US Census data. So we have to, and I'll combine this with the next slide, in order to address this challenge, we either need a legislative fix or we need permission from the court to go beyond our statutory deadline. We either need that or we need some sort of legislative fix that allows us to use other types of data. And Brian Pollock's going to talk more about the legislative efforts. Next slide, please. All right. So what we did, given the the current inability to use anything other than US Census data, we did list out here, and we don't have to go through these, but we did list out for the county board the various tasks that could be performed prior to us receiving US Census data. So as the Madam Chair appointed the Reapportionment Committee, there are a number of different things you can do. First of all, of utmost importance is setting that size of the board. You're making a recommendation to set the size of the board that will then go to the county board, and we can kind of proceed with planning. We can proceed to develop a preliminary draft plan using data that is available to us, which the county has is under ESRI provider, ESRI software provider that uses American Community Survey data. There are some limitations to that data, but that would be a good way to start off in terms of developing a preliminary plan. And there could be a legislative fix and would actually perhaps adopt the use of ACS. I think that's in consideration with some of those bills that will be drafted and submitted to the legislature. Next slide, please. Then we just laid out for you the basic process once we do get US Census data or other data that is approved by the legislature or approved by the courts for us to use. And so in essence, what you do, in Roger Fonstock, the executive director of IT, is going to further explain this to you. We download that data to create in our ESRI platform to develop the maps. And it's, I'll let him do the tech stuff because I will never do it justice. But we will develop the maps. You will give input on that. You'll make recommendations. You're going to be talking to community groups, minority organizations, the general public, residents, all interested parties to try to get information to supplement the data we have so we can identify issues so that you can have the best map possible for the county. And then it'll be submitted to the county board. The county board will adopt it, and hopefully it'll be a unanimous decision. And hopefully it will stand any court challenges. But at any rate, we thank you all for your work. It is a very important job to make sure that all residents of Kane County are represented equally. And we just really thank everyone for their dedication and their willingness to volunteer for this task. With that, if anyone has any other questions, otherwise I will turn it over. Oh, yes.
Mr. Meyer?
Very briefly, one housekeeping matter. I certainly don't have any objection to the presence or involvement of a particular legal expert to guide the
Microphone.
mission or task force in its duties, but I do want to know, how does
Microphone?
Microphone.
there? Is it on now? Okay, sorry about that. I'll learn the protocol, I promise. My question was concerning the appointment of or retention of a special assistant to guide the task force. I certainly have no philosophic disagreement with that, but I do want to know, how does that comport with the Smollett decision, the Kim Fox recusal case in Cook County? The court in that case seemed to have a very skeptical view of the retention of special assistants absent or without using the process prescribed by statute for appointment of a special prosecutor. And their decision wasn't just confined necessarily to the facts of that case, but what they said is that if the state's attorney is not absent, sick, or unable to perform their duties, then in that circumstance, you have to go to court to have the court appoint a special assistant. But their conversation goes beyond that and says that, this notion of special assistants just being unilaterally appointed by a state's attorney's office is not something that exists in statute. It's by law, it's the county board's responsibility to set the number of state's attorneys or assistant state's attorneys, and they were very skeptical of that. So I'm just wondering, have we dotted our I's and crossed our T's in that regard here to make sure that we don't have any conflict or problem with retaining outside counsel to assist us with this? That's part of my question. Then I guess the other half of my question is, where are the funds coming from that are paying for retention of a special assistant to help us in this process? Is that coming out of the state's attorney's budget? Is that coming out of the county board's budget?
Yeah, I'm not sure it's extremely relevant today, but in terms of special assistance, parties can go to court to try to have a special prosecutor appointed by the courts if there's some sort of conflict or unavailability of the state's attorney. Historically, our office, as well as offices all across the state of Illinois, have appointed special assistant state's attorneys when they need just simply additional expertise or staffing, to be quite honest, outside of the state's attorney. So it's more of a contract attorney in essence. The state's attorney does have a budget for outside counsel. And so initially, at least, that's what we're going to be drawing upon is that budget for outside attorneys. So it's very common, whether it's in civil rights cases or, if one, say a deputy is sued or something like that, and we have a conflict of interest, they've been sued in their individual capacity for punitive damages, say, we will appoint a special assistant state's attorney in that regard. So the concepts are a little bit different in terms of the statutory concepts versus us appointing someone as more or less a contract attorney.
Well, there is no express conflict of interest here. State's Attorney Mosser isn't recusing herself from representing the board in this,
No,
right? So
no.
we're talking about the other basket where the state's attorney's office is seeking outside counsel to assist them with what is their statutory and constitutional responsibility to advise the board in this regard. So again, I guess that would then be my second question, or the second component of my first question, which is, does that require county board action to approve retention of counsel to do that? Because the county board is who sets the number of assistants that are to be, employed by the state's attorney's office.
Correct. This is not a full-time employee, so that would be the assistants. But the county board has already approved the concept of special assistants because they've provided for contractual employment. So in each budget ordinance, they would approve the hiring of outside counsel through that line item.
So your opinion is then that the board has met the prerequisite requirement to give that kind of authorization to the state's attorney's office to retain the counsel?
If that is the theory we're going on, which I'm not sure I completely buy into, but if that is the theory we are proceeding on, then in any case, the county board has approved it by adopting that budget ordinance.
Okay, thank you.
You're welcome. Thank you.
Any other questions? Thank you, Michelle.
Thank you.
I'd like to introduce now Brian Pollock. There he is, from the clerk's office, who's going to be talking about proposed legislation and perhaps a little bit more about can you speak about the American Community Survey?
Sure, to a point. Roger will probably have a little bit more on that when he presents, but good afternoon, everyone. Thank you to the committee, Madam Chair, for the opportunity to be here. My name is Brian Pollock. I do want to send regards from County Clerk Cunningham. For those of you that didn't hear it yesterday, the clerk's office is more than willing to help in any way possible, even though this is a county board function at this point, to do anything that can assist in the redistricting. So we're here for you for anything you need. This Assistant State's Attorney Neerman mentioned the issue with the data and with what the statutory provision in the county code says this committee is to use for data. The statute, as currently passed, states that the population is defined by the last preceding federal decennial census. So we don't have that 2020 data. We have 2010, that's not a good option, and we don't have 2020, so what do we do? The clerk's office has been working with other clerks around the state because every other county is dealing with the situation, and so we've been trying to find a solution. And it's a challenge because not every county is the same. downstate, a lot of these smaller counties don't have these issues. They didn't have any population changes. They don't have significant minority populations. So some of their answers is, we'll just leave it the way it is. Hope we don't get sued. Everything will be fine. That's not an option for us. Between our growth and our population, the way that our minority population is in Kane County, that's just not going to work. So we've been working with the other county associations as well, because this is not just a clerk's issue, it's a county issue. There was one proposal, there was a reference earlier to Senate Bill 1666. ISACO, the Illinois State Association of Counties, had thrown together a proposal that would have pushed back the July 1st deadline back 6 months. Great, maybe the data will come out in 6 months if the Census Bureau does what they say they will, but we have this pesky election that we have to deal with. So March 15th, 2022 is going to mean something to every county board member, candidates, and then every state legislator. So, and if you follow the timeline back, your filing period for 2022 is bracketed around Thanksgiving, and your circulation of petitions begins on August 31st. So we'll get back to that soon. So pushing back the deadline for the counties to pass a redistricting plan 6 months doesn't work with the election. So that bill wasn't going to go anywhere. And then ISACO said, well, let's push the election back to June. That's also a non-starter. The legislature is not going to do that. They're all up in March. They're used to it. They're not changing anything. Not for us, not for anyone. So those proposals weren't viable solutions. So we've tried to come up with something that would allow us to use data that's available now. So we came up with language that's very generic. Instead of that last preceding federal decennial census, we'll define population as the number of inhabitants determined by the most recent data available to counties from the US Census Bureau. And the ACS, or the American Community Survey data, is from the Census Bureau. So that data is from 2019. And that would be certainly more recent than 2010. And in the fact that 2020 is not accessible, it's something. So the cat's been let out of the bag. That's what the legislature is going to use to draw its maps. So it's not really a secret. President Harmon said that's what they're going to use. So what's different? And you can say, well, if they're doing it, well, why don't we just do it? When the legislature draws its maps, they don't have a county code that tells them what they need to use, what their data source is. They don't have, the Constitution says they can draw a map, and they have to draw a map the year after redistricting. It doesn't say what they have to use. So they'll draw a map and they'll pass a law that says, here's what we used. And that's okay. We can't do that. We have to go by what the county code says. So we need to amend that. And so the issue is if that's good enough for them, and there are questions about, there's always a lawsuit. So I'm not going to talk about the merits of what's going to pass. I'm not acting as a lawyer here, but if the state's using it, the theory is, it's probably good data and it's something that we can use. Coincidentally, if you look at what Congress just passed in terms of the federal money coming in, both for the CARES Act and for the American Recovery Plan, the way that they determine population is based on the 2019 ACS data. So the feds use it, the state uses it. So that's the proposal that counties are looking at to use that data. So we've got buy-in from the Illinois Association of County Clerks and Recorders, from the Illinois Association of County Board Members, and from UCCI, the United Council of Counties of Illinois. And so all the county groups and the clerks groups have decided that if we can come up with an answer, then we can take that to the legislature. We have spoken to the sponsor of Senate Bill 1666. Again, that's not working, but Senator Holmes has indicated that once language comes in that's approved by everyone, she'll work on it. And there's another option that we're looking at as well with a bill that's already been passed through one house that might be easily tweaked and amended too. So we have a couple paths to do this, but really that's really our mission at this point, is getting something so that you're not waiting and having a real data source. I mentioned the timeline earlier. The statute says July. From the clerk standpoint, July is probably a safe bet in terms of if you want everything ready for the election cycle to run on time. It's, as I mentioned, the petition circulation season starts at literally the end of August, the beginning of September. Unfortunately, you can't just pass something the day before and expect that the machinery is going to run on time. We have to update, you're going to be changing districts. So we have to update all that information into our voter registration system. We have to inform the voters. We have to draw the maps. We have to, it takes time to do this, and there needs to be some lead time. So getting it done by July would give, if you're passing at the board meeting in July, that would give us, 45 days or so to get things done. So it's not just the statutory deadline, it's also realistically being ready to run an election. So I'm trying to keep this short, so that's what I have. If there are any questions, I'll be glad to answer.
I got a question.
One question for Mr. Shepro.
So I think you may have answered this already, but there's been some discussion about, well, you adopt a map now and you tweak it in September. What does that do to the preparations that you talked about? It seemed to me that that's maybe not quite starting over again, but pretty close to it.
From a efficiency and running an election, that would not be a good option.
Yeah.
From a legal perspective, that's probably something different too, but that's not a good option.
And as I recall, a number of clerks were talking about the lawsuits that were filed before the 2020 primary with respect to minor parties and so forth. As I recall, either the clerks were initial defendants or intervened, saying, we can't do what you are ordering us to do. I think at that time, it was a July deadline or an August, it was August deadline for the November election. So I assume that there would be significant practical difficulties, whatever the legal framework is, if everything is left as is.
We have to follow what the statutes tell us. If a court tells us something different, that's a different story. But when it comes to this, we have to follow the law.
But if the statute says the filing date is November 30th, and it turns out that you get a new set of maps on November 1st, that's a problem, it seems to me.
But if the statute still says the filing deadline is November 30th,
yeah, that's okay. More later.
Spates?
So, Mr. Pollack, you did sort of explain why we couldn't use the American Community Survey, because we can't just make up a new way of doing this. But will we do it? Will we find a way to do it that way? Is that the plan?
I think the plan is to follow the law, and we're looking at changing the law.
Will the law be changed so we can do this?
That's what we're working on.
That's what we're working
I
on.
think that's one of the things this task force is going to have to.
Well,
There's a good possibility that it will be. But
we have many questions right now. Mr. Meyer? Yes, Mr. Gately.
The Democrats, we're okay with American survey data from 19. It's which we're going to have, everybody's going to have to go with that route. Every county in the state is going with a, remapping process. Everyone's using that same data that I'm aware of.
It is the only data
That's the data
available.
we have to use. So we're okay. No problem there.
So my quick question was, did I hear that though the competing problem is that there's a county ordinance or there's a county language that only allows for the census? So the county
state statute in the county code, yes.
Right. So the county code would have to be amended to allow us to use this PCS data first. Then we could use it to meet our July deadline.
Correct.
My question to you about this, what you're seeing at the legislative level, since they're trying to do that there in the statutory work, are they doing this as a temporary, this is a 2021 situation? Are they looking to change the statute forever? Or are they saying this will apply specifically for this year only, and we will essentially back in 2030 be going based on the statutes? Do you know?
They're not looking at anything. We're bringing it to them.
Well,
It hasn't been on the radar. So we had language that originally said only if you don't get data by this time, and it turned out to be long and tortured. So with this language, it still says the most recent. So if everything goes back to normal in 2030 and the data comes out, in March of 2031, that's still the most recent data. So by using that language, it doesn't say you have to use ACS. It says the most recent data available. If the most recent data available is the actual census data, great. That's what we want. So this doesn't change that. It's not giving a county the choice to say, well, we like this one better than this. No, it's whatever the most recent data is.
Mr. Meyer.
I know this is a catch-22. We have to, at least for now, kind of pick which proportion or which provision of the law we're not going to follow to its letter. The problem with that is that I can't tell you how many times I've been in front of a judge and he's told me, well, Mr. Meyer, I understand your argument, but this is what the statute says, and that's not what your client did, or that's not what happened here. So in the event the legislature doesn't change the law and we've used the ACS data, then I think we stand in great peril or great jeopardy of having whatever the board adopts challenged, and there's probably a modicum of potential success in that challenge. So have we considered, or should we be considering prophylactically seeking an injunctive order, some mandamus, a declaratory order from the circuit court saying, hey, have at it?
Yeah, we kind of skipped over the slide. Basically, the two options would be a legislative fix or go seek a court order, excusing our compliance, essentially.
Okay. So I think that we had agreed with the board yesterday that we were going to move forward using this data. And as a draft to move it forward in case it does comply, because otherwise we will have to wait until the court decides or the legislature decides what data. And then if we have that July 1st deadline, we are going to be crushed for timing.
Yes.
So I think we're being very prudent to move forward with this, and hopefully there will be a legislative fix. If not, then court order. I think that would be the next step.
Madam Chair, I have no concern about doing that. I know we have to move forward. I would just say maybe for consideration, judicial solutions are not instantaneous either and would require an opportunity for interested parties to be given some form of notice and an opportunity to be heard. I think due process would require that. And so in a best case scenario, you're looking at a matter of, if it's a state court action, it could be 3 or 4 weeks. If you file in federal court, it could be even longer. And so if a judicial remedy is something that the board is going to seek, I would think that maybe something they need to be considering moving on, at least in parallel, sooner than later, because if we're going to try to get this all wrapped up by July 1st, you don't want to wind up going into court on June 15th and trying to get a federal court order or even a state court order to give you permission to what we've done at that point, especially if we have to shift gears or modify what we're doing because the court says you got to add this into your process.
Yes, we don't disagree.
I didn't hear that, sorry. Don't disagree.
We don't disagree. Sooner the better.
All right, very good, very good. So, yes, Mr. Shepro.
I mean, I would think that a prudent candidate faced with all the potential difficulties of what if this doesn't happen, and now you're scrambling to meet deadlines which you may not be able to meet anymore, I would think some candidate is going to file a lawsuit if we don't.
Well,
Somewhere in the state. I mean, I guess we'll deal with that when it happens. But
I don't think that, with all due respect, this is not that decision by this board, what or will not a candidate choose to do. I think this task force is truly assigned to develop with the best data that we have at this point, to take a look at the reapportionment, size of board, and then the redistricting and how that is going to work to make sure it matches population. So if we can, thank you for that, those comments, though. If we can continue. Mr. Pollack, thank you very much. Now, the next one, which is probably, I think, the most engaging, which we're all here for, is to take a look at population size and how it has changed in the maps.
Thank you, Madam Chairman and members of the task force. Carson, you got the right slide. Okay, good. Thank you. My name is Roger Fonstock, and I'm the Chief Information Officer for the county, and I also run the county's Geographical Information Systems Department. So we do maps. So the good part is that in my tenure here at the county, we have done this twice. I was here when we did the 2000 census, the 2010 census, and then now the 2020, which we're waiting patiently for. In the process of doing this, the last time they did redistrict, they reduced the size of the board. So we had a lot of drawing to do in the last version of the maps, and that was approved back in 2011. Up near Madam Chairman in the center is the map with the current population, and that's the one up on the screen. The one to the left, my left, right of Madam Chairman, is what the populations were in 2011 when they redistricted. There's another copy of a map we'll share with you that was from 2000 census that was completed in 2001. That's in a electronic distribution we'll get out. And we'll have some of these other maps up and available in the room as you folks are here meeting. This map, I think the most interesting part of it, Carson, if you'll go to the next slide, is the population changes and some of the sizes of the district. This shows you the population of the districts as of the most recent ACS estimate based on the 2010 census. So they take the 2010 census, and every year they're doing the American Community Survey on a 5-year type of cycle where they update and they do a survey of a small sample of the communities. And from that, they extrapolate and they extend that to the population. So this is population. It has race and ethnicity. And that basically is representative, are represented by district. We also sort it by population. But what you'll see is there's some districts that have grown considerably, maybe as much as 20%. There's other districts that have grown, somewhat less. There's districts that have, large Hispanic populations and some that are relatively small. You'll see, a lot of change between the last census and what the community survey has done over the last 10 years. But this is some of the data from the ACS that's based on an extension or enhancement of census data. Now, the one thing I would point out is that there is a margin of error, and that's, I think, the concern. We don't have the census data. It's not supposed to be available till September. And that's what the time constraint is for getting the actuals from the census. And I think Madam Chair has even suggested or stated that, even if we get those in September, there may be some questions about, methods and things that may not be entirely accurate or that we have concerns about with that anyway. So right now, the best, most accurate data that's used for planning, that's used for decisions in Illinois, in Kane County, has been the ACS data that's extended from the most recent census. Carson, if you'll go to the next slide. We also have provided in this packet the state of Illinois representative districts, so you can get an idea of what those look like. And we also have population, Carson, if you go to the next slide, that is respective of the representative districts in Illinois. Again, you're going to see some of the population changes. What we're going to do as an IT department, and we're here as staff to help you with getting information, getting maps, working on the recommendations from this task force to formulate that into new maps, new numbers, bring them back so that you can consider those, and then we start over. I refer to this a lot of times in terms of review, analysis, recommendations, revision. And it's an iterative cycle. You're going to go through it several times before we get to the final map that's going to be recommended. We plan on using legal and demographic advisors, so demographers and legal assistants. I know State's Attorney Neerman already mentioned the legal counsel. We're going to be working with our GIS team and some professional demographers to help us, not necessarily with the numbers as much as understanding what the representative numbers mean in an area. How is it, put together, the neighborhoods, the school districts, the general population that makes up what would be a district, just to help us understand, help you understand, so you can make some informed decisions about where you draw lines. We've had over the years challenges where you're drawing lines through neighborhoods, through front yards, backyards, down streets, around buildings. It really helps to get a feel for who you're affecting, what you're impacting, and how that looks on a piece of paper may be different than if you're out in the neighborhood talking to people. So there's been some discussion about how do we reach out and pull in, some focus group type of information. We're going to be working with you on that. But again, the meat of this, or the most work, is getting those maps drawn and going through that iterative process. Couple of other things that I would mention is that our GIS team has been together with us for a considerable amount of time. We probably have 20 years of GIS expertise in that department. They're very good at what they do. They've generated all the maps that we've provided over the last 20 years. I think that with consultation with legal and the demographers will give us a really good map. It'll be very informed, educated opinions about what we have. So in that regard, you're in the driver's seat. You really have good staff, I think, that will help you get through this. One other piece of information, you're going to be meeting frequently, and we need feedback from this group, from the board members and task force. We're going to be focusing in, kind of laser focus on what comes out of this task force. So we've already informed kind of the peripheral, the people outside of that they have to go through this task force to conduct business, for us to work on maps, for us to consider any changes. So as you're talking with people, please remember that any of the work that we ask GIS or the staff to do, we need to come through this task force and through legal, so we follow the proper channels. We want to make sure that all the steps get followed, dot the I, cross the T. We have some time constraints. I mean, Brian Pollock mentioned some of those for elections, but there's also a lot of dates in the statutes and legal part of it that we have to follow. So having those constraints are important. A few other things, Carson, if you go to the next slide, please. This one is the congressional districts in Kane County. So you get the 14th congressional district, takes up most of the county. I will tell you that back in before 2010 census, 14th congressional district was, I think, all of the county. So we've had a couple of the other districts kind of creep into our county over the years. If you go to the next slide, Carson, there's, again, demographics and data. So you're going to see this constant theme where we're talking about population, we're talking about the size of the districts. Obviously, that's important, but then what is the makeup of the district and how does it look as far as the population? We're going to be trying to provide you some of those decision-making factors. Last piece, and I don't know if that we need to go through the next slide, Carson, I think it's just an example, but this is the precincts. One of the things that was mentioned by State's Attorney Neerman was trying not to split precincts, trying not to split districts, trying not to, split people that have common ballots or common ballot styles. I think that's a big challenge. We have hundreds of different districts and things that we keep track of. We can layer those onto maps and show them to you so you can see what effect, your district lines have. But I will tell you that, once you get started down that methodology of slicing and dicing it by, different districts, it's a lot of different districts: school district, water district, fire district, municipal. So just so you're aware that there are all of those maps, all of those layers are available for this task force to look at. But we're going to be, working with you on the maps and the recommendations that you make and trying to bring those back for your consideration. Again, it's going to be this iterative process where you're going to look at things, you're going to review some analysis, some professional and different advice, make recommendations. We go back to the drawing room, we redraw it the way you ask, bring it back. And that's a cycle that's going to go through. I think we discussed 3 or 4 cycles of that type of iterative process. So the last piece is just to be sure that everybody is aware, we are looking at ACS data. So American Community Survey data, and this is the most recent version of what they have based on that survey. And again, we won't be receiving the census data probably till September. And even with the September timeframe, we get block data or track data from the census, and it will take us weeks to bring that into GIS data layers and kind of conform it so that we can use it. So even October or November is probably the earliest we'll be able to functionally use census data for our purposes. So that gives you kind of the time frame of what we're looking at. So again, the ACS data is what we're looking at right now and what we'll be working on with the first couple of task force meetings as the legislative and county code gets worked on. So I'd be happy to answer any questions if you have them.
Ms. Bates.
Thank you, Madam Chairman. If we do all this work with the ACS data and go very far down the road, and then in August or September, you said we get the real census data, are we going to backtrack and do it all over again? Or will we stick with the ACS until the primary or are we setting ourselves down that path and know it? And know we're going to stick with it.
I think that's a legal question, but I think that at this point you won't have any other data, per se, from the census, which is the legal kind of letter of the law. So I think that's the question is what else would it be if it's not that? So.
Again, as we've discussed, this is all highly dependent upon whether we have a legislative fix or a court fix. We have to comply with the statutes, so it's all up in the air, unfortunately, right now, Ms. Bates.
Thank you. Can I just mention the way the precincts have grown as we go through this? We're going to start with the macro. Choosing, of course, the size for the rules of engagement, how many board members, and then the redrawing of the districts based on population, et cetera. But then as we get down to the micro, we have had some significant growth in different areas within the county. We have 17, it was 500 to 800, and for everybody here who may have walked a precinct or is a current precinct committee person, you understand the difficulty of knocking on many, many doors. We have 17 precincts currently that range from 1,500 to 2,000 population of voting members. I'm sorry, excuse me, voting members. We have 20 precincts that have up to 3,000 precincts, from 2,000 to 3,000. We have 3 precincts that have from 3,000 to 4,000 voters. And we have one is the grand winner, Rutland 2 up north, has 7,500 people in it. So those are precincts that are going to have to be carefully looked at and obviously culled. Currently, there are 291 total precincts within our county. I don't know how many additional precincts there may be. I don't mean to bother the clerk with this, but this may be a reality that we're going to be facing. So they will also have to be redrawn.
There was one other set of slides about population. If you'd like me to go through those, Madam Chair.
Yes, please.
Okay. So Carson, if you could take the next slide. So we had development. They pulled some numbers from CMAP together, and one of the questions that State's Attorney Neerman mentioned was the sizing of the board at 800,000 based on the statute. It would be reduced to 18 board members. So once the population hits 800,000, there's a statute that kicks in that you have to downsize down to 18 members. So we were looking at population from the past and projections. This was just for interest's sake. This is from the time of the time that Kane County came into existence, and I think it was 1836 to 2010. And then Carson, if you go to the next slide, you'll see the current growth from 2015. And then these are projected numbers from the Chicago metropolitan area planning. So they go through and show you what they believe to be accurate projections of population. If you look at 2020, we're somewhere in the 530, 540 thousand range right now. So they're a little over projecting. But if you go out, they don't really project us hitting that 800,000 population till sometime beyond 2040, 2050. So it's on track. We're growing. We're actually growing at a rate kind of disproportionate to some of the other collar counties and areas downstate. We're growing faster. But it still doesn't show us projecting out to 800,000. But in the next 2 census periods, you're going to see that start becoming a reality. Carson, if you go to the next slide, this is county by county CMAP data, 2015 to 2050. And we're still the 5th largest county across the board in the collar counties as you go across. And you see us again in 2050 approaching 800,000 in total population. So that was just something that development put together and transportation department. I wanted to share that because that's one of the questions was about the size of the board and the statute that requires the changes to the size of the board.
Thank you. Yes, Mr. Shepro, question.
As I recall, the number we used for CARES Act was what, 532,000 approximately?
Yes, we actually used an ACS 2019 estimate.
And as I recall, the city of Aurora in particular, and maybe Elgin also, had indicated that they believed those figures were too low for their population. And that's another thing that perhaps we have to.
I think there was some question too about Aurora being in 4 counties versus just Kane and Elgin having population that is in Cook. And there's some, different nuances about where their population is. So yeah, the ACS doesn't define it as clearly as the census. A census goes down to, a tract block in a neighborhood. It's down to the street. So
I think you mentioned that the ACS data was based on a sampling and then extrapolation from the sample.
Yes.
Is there, I'm trying to think of the right way to do this because my last math course was as a junior in high school. Are there different levels of reliability of those extrapolations depending on what's being extrapolated? And I guess the 2 I would call out would be the overall population extrapolation versus the minority population.
They do have some, what I would say are margin of error. They're examples. I don't know that they're statistically significant. They're in the, plus or minus, some people say plus or minus 3%, 5%, 10%. I think we've seen things that are, in the 10 and under is pretty common, 10% margin of error. But I believe that State's Attorney Neerman would tell you that you may have even greater deviation than that. So, you could have something that is a 20,000, member district or 20, and maybe you're off by 1,000 people. That's kind of a margin of error.
Is the margins of error identified somewhere in?
10%.
Yeah, they have some in the.
10%.
And we do have the sources for all the data. If you want to see those, there's literally a source reference for the ACS, and it tells you how they calculate everything. I didn't want to get too far into that, but we could if you want. I think I have it.
Madam Chairman.
Yes,
this is,
but not today. Yes, who's that?
This is Phil Lukihans. I may be able to answer Mr. Shepro's question to a little. Mr. Shepro, as far as demographics, the ACS is actually it's built for demographics. So the demographic numbers are probably closer than the total population numbers. So the percentage of Latinos, percentage of African Americans, that's primarily what it's been used for. So we'll probably take that with a little more, it probably has a little more accuracy on a percentage basis than it may or may not have on total population, which I think was your question.
Thank you. That's very helpful.
Thank you very much. Yes, Ms. Bates.
Does this, do these CMAP projections take into account the fact that the birth rate in Kane County has been dropping by over 1,000 per year?
So the numbers that they have would be based on whatever is in the community survey. I don't know that they specifically how they incorporate birth rate, but we could find out exactly, what they consider. Survey data isn't usually like computational data where you're calculating real numbers. It's a survey of a community segment or a sampling size.
Oh, okay.
So there are other numbers though that we get, and I had some, I was going to bring them, but we did go out and look at other population estimates from IDPH and DCEO. And there's some other sample data that we can use to kind of cross-reference while we're doing this and say, well, IDPH says that this is their reference population within, and where did they get that from? They did their own study based on their own data. And we can use some of those as good, reference points to see how far are we off from what ACS says. So is there any, abnormality or difference that we should notice? I did that with the gross population for the county. And I think I came up with two numbers for 2050 that were within 5,000 people. So, and you're going out 30 years. So within 5,000 people is not really significant difference. I think you'll find those types of things, and I believe that's the type of accuracy. So, when I'm not sure exactly what the legal description is of a district size or the accuracy, but I think I heard some things about being within 10% or being within 5% of so you're already dealing with margins, I think, at this point, and these are pretty small margins when you're looking at the demographics.
And again, we're all speaking hypothetically now until we actually see the numbers. So if there are no other questions, because I am being sensitive to time, thank you very much. I would like to table E until our next meeting, when we actually start talking about that. So if we can, I believe I need to have a approval. Is that correct, to table this? May I have a motion?
Motion to
A
table.
motion to table the presentation discussion of
next meeting.
ordinance dash to our next meeting.
Second.
Thank you. So, thank you. Do we need
Roll
vote?
call.
Roll call, please.
Ford,
Yes.
Fraz,
Yes.
Gums, yes.
Kenyon,
Yes.
Martin,
Yes.
Sanchez,
Yes.
Shepro,
Shepro, yes.
Strathman.
Strathman, yes.
Thank you. I would like to schedule a meeting next week to simply discuss the size of the reapportionment. So could you please check your calendars? And I apologize that I did not bring mine. Would you all be available this time next week?
Yes.
Yes.
Is it an agreement? Very good, very good. So why don't we will schedule that, and that date of that meeting is
29.
perfect. Same time, same place. At 3:30. What I will ask you to do during that period of time is to reach out to your communities, have a conversation with them, ask them how they feel about either keeping the board size the same, how they would feel about reducing it. If it were to be reduced, I believe the recommendation, so that it doesn't shock the system too much, would be slight, simply by 2, so bringing it down from 24 to 22. So it is a gradual decrease, or it can stay the same. And if we look at the numbers the way they are now, we have a bi-decade, so that no changes literally have to be made if we obey the letter of the law, since we don't have to worry about it till 2050, but the following 3 decades, then starting in 2030, if the law is not changed and if it does remain the same as it is today, the future boards will have to do that. So that'll be something that we can talk about at length to see what that looks like and what your communities feel. Yes.
I would make a request of our attorneys. one of the considerations, perhaps the principal consideration that seems to be driving the conversation about the size of the board is this Naperville, what we describe as the Naperville provision, where they mandated that their board be certain size. And I'm trying to remember my legislative interpretation class, which I had over 50 years ago. So my memory is pretty foggy, and I'd like our attorneys to look at it. I don't know, as I look at it, that I agree with the conclusion that we are mandated to do this when we hit 800. I mean, if there's a reference, if we assume that the reference to 2002 and 2000 is in there for a purpose, it's either superfluous or it was meant perhaps to point more clearly to Naperville and isolate it. And I may be dead wrong. And if I'm wrong, I've been wrong many times in my life, but I would like to know that our council have all agreed and that this is in fact an event that will occur when we hit 800,000 and not something that we can feel comfortable not worrying about.
As the legislation stands right now, it does not apply to anyone other than DuPage. However, it was anticipated that back in 2011, that when they were doing planning and reapportionment, it was anticipated that future legislation would be adopted to apply to us at that time. So as the statute reads right now, I agree with you. It does not apply to future counties that reach 800,000. It's just anticipated that new legislation would be enacted to apply it.
And they were going to do that in 2011?
That's sort of the premise they worked under in 2011.
Well,
they were anticipating that the legislature would change. And I know Ken had a really nice explanation yesterday regarding sort of the history and, the
likelihood
moving
that
of the
they're moving down the
goalposts,
boat.
basically, yeah.
My concern is this: we've got a skillet that's about this big, and we've got enough fish to fry that we're beyond the size of the skillet, and at least amongst the 6 people I've been able to talk with, there's not a huge concern about the size of the board being anything different than 24, and I don't want to be chasing that issue and complicating other aspects of what we need to do here, unless it's just, and even if it is necessary in 2050, and I'm announcing one person's state of mind, I might say
no.
heck with it, just pass it up.
It's a complete policy decision.
We got a bunch of
It is.
stuff to do here. I
Mr.
guess.
Martin, can we, again, I'd like to, because of the time, if we can, it's going to be a thoughtful discussion and one worth having. If we can table all of that until next week, and our state's attorney will do a fine job of explaining what the law is and why this has come about and what the rationale was for 2011 to reduce the size of the board, which was done by this board for that purpose following that. And I do have precedent from that. So that's where I was taking my direction from.
Oh, I understand we've done it before.
But we can talk about it at length at the next time. The other item on the agenda, I think we can start talking a little, because I'm hoping that this discussion is not going to take 2 hours to make that decision. It may, but I'll also be putting on perhaps an introduction to some of the maps, and we can go into a little bit more detail talking about, again, the macro part of it, taking a look at populations and where the populations actually have shifted in detail, so you can starting to feel about that and getting a little bit more population knowledge. And the one other thing before I let you all go, if I may, I think it's very important that we reach out to our communities as we go through this. I want to make sure that it is an open process and one that is meant because of the current climate of wanting to make sure that all voices are heard at this table, that I would like to have minimum of 3, perhaps even 4 reaches out to our community so that there would be the opportunity to bring community members to their community, not have them come here to Geneva, so that we can meet with them and discuss the maps per their district. to make sure that they are well represented. So certainly Aurora would be one, Elgin, of course, somewhere in the midsection, and then perhaps because of the large growth that has happened up in Rutland, an appropriate place up there as well. So that would be my recommendation, and I would hope that members, representative members of those communities would be joining us there to listen and to learn of what people have said, and actually to make record of their recommendations, because they do know their community best.
Would you put that on the agenda for the next meeting?
I will definitely put that on the agenda for the next meeting. So, yes, sir.
Excuse me, this isn't directly relevant, but for those who are not aware, Mr. Weber formally submitted his resignation letter yesterday afternoon, effective, I believe he said, May 3rd, which would be the moment that he would be sworn in as an alderman. And so that at least impact the number of people voting on some of these issues.
Okay, thank you for that. If there is no need for an executive session, may I have a motion to adjourn?
Move to adjourn, Madam Chairman.
And your
Mike
name, sir?
Kenyon.
Thank you.
Second,
I'd
Shepro.
like to get us out of here. You have things to do.
Aye. Any nays?
Okay.
Again, thank you very much.